this situation, Insolvency and Bankruptcy Code was brought in. I request Mr. Arun Karthik to throw some light on this Insolvency and Bankruptcy Code, and we'll be taking a Q&A session after his presentation. Please, participants, please post your Q&A in the Q&A option that is given in your screen, so that moderators will take up the question and Arun Karthik sir will be answering that. Over to you, Mr. Arun Karthik.
Thank you very much, Mr. Bala. A very warm welcome to everyone to this webinar. And I'd start by placing my thanks to the entire team at Mrs. T.S. Gopalan and Company for giving me this opportunity to address you. So as Bala had mentioned in his introduction, there is, of course, a specific objective with which the Insolvency and Bankruptcy Code was introduced way back in 2016. And the fundamental objective in the sense was to consolidate the laws pertaining to insolvency and rehabilitation of companies which are being driven to insolvency, and to that extent the consolidation is essentially twofold. One is consolidation between laws relating to insolvency and liquidation, as well as laws relating to rehabilitation and restructuring. If, as some of you may be aware, prior to the introduction of the Insolvency and Bankruptcy Code, there were the provisions under the Companies Act 1956, which provided for winding up as a statutory remedy for inability of a company to address its liabilities. And at the same time, there were provisions of the Sikh Industrial Companies Act, or more briefly referred to as SICA, which also provided simultaneously a chance for companies to engage in an exercise to try and rehabilitate and revive the companies. Now, essentially, through the Insolvency and Bankruptcy Code, you have a consolidation of both the jurisdictions into a single code which addresses both issues at separate stages. And that is something which we will try and look at in the course of my presentation. The second realm of consolidation has been with regard to the various entities or persons that could be made subject matter of insolvency proceedings. Now, these could be, of course, ranging from companies, bodies, corporate, statutory bodies, corporate, LLPs, partnerships, individuals. Now, there has also been a consolidation of insolvency procedures with regard to all these various entities under the Insolvency Code. So the consolidation in that sense is twofold. Now, moving ahead from that, when we spoke about the consolidation of various entities, the broad structure of the Insolvency and Bankruptcy Code is divided into two parts. One part dealing with insolvency, resolution, and liquidation of corporate persons, typically companies and LLPs. And the second limb pertains to insolvency of partnership, resolution and bankruptcy of partnership firms and individuals. Now, the provisions with regard to insolvency of corporate persons has now been in effect from 2016 itself. Whereas for the longest time, the provisions with regard to insolvency, resolution, and bankruptcy of partnership firms and individuals was not notified by the central government. Now, as of December 2019, the provisions which are in Part 3 of the Insolvency and Bankruptcy Code, which pertain to partnership firms and individuals, those alone have been notified, and that too only to the limited extent of dealing with individuals or partnership firms which stand as guarantors to corporate persons. Therefore, at two levels. One is these provisions itself have been brought into effect for guarantors, individual and partnership firm guarantors, only in December 2019, which is about 2 months back, and if you exclude the lockdown period, then effectively it's been in force for a 2-month period. And secondly, it is not as such opened it up to in initiating insolvency proceedings against all individuals and partnership firms. And so it's only to the extent that the guarantors are guarantors related to corporate persons that these provisions have been notified. So essentially, the bankruptcy code has thus far remained broadly in effect and implementation with regard to insolvency resolution and liquidation of corporate persons, namely companies and LLPs. And that is the reason why our webinar today is largely going to focus on the broad procedure and overview of the insolvency resolution and liquidation proceedings with regard to corporate persons. Now, there is one other fundamental difference that one may want to point out at the outset with regard to the adjudication process for corporate persons vis-a-vis partnership firms and individuals. There is a difference between, as you would be aware, the process of insolvency resolution and liquidation is the adjudicatory process, at least, is driven by something called an adjudicatory authority, which has been defined under the code to mean the National Company Law Tribunal as far as the insolvency resolution of corporate persons is concerned. And it is best jurisdiction upon the DRT, or the Debt Recovery Tribunal, as far as insolvency resolution and bankruptcy for individuals and partnership firms are concerned. Now, moving forward, when we are dealing with insolvency resolution and liquidation of corporate, this is covered by Part 2 of the Bankruptcy Code. And essentially, if Section 3 of the code talks about 3 categories of persons who are entitled to maintain and Section 4, there are 3 categories of persons who can institute insolvency proceedings against a corporate person, that is a company. They are defined as A, a financial creditor; B, an operational creditor; and 3, the corporate debtor, or the person who is subject of the corporate debt, can also initiate insolvency proceedings against itself. Now, as far as financial creditors are concerned, financial creditors are defined under the Insolvency Code as those who are owed what is called a financial debt. Financial debt itself is defined under Section 5, subclause 8, clause 8 of the Insolvency Code. And typically, if you were to, in sum and substance, the scope of financial debt is essentially debts which are due under loan arrangements. And that is the reason why a large portion of exposures of banks and other financial institutions fall within this category of insolvency resolution or insolvency proceedings. Now, the trigger point for a financial creditor to approach the NCLT to commence the process of insolvency resolution is what is defined as an instance of default by the corporate debtor. Now, default has also been defined under the code as meaning any circumstance where a payment due has not been honored by the corporate debtor. So that's the broad definition of default under the code. And upon such a default coming into force, any financial creditor, either individually or as a group, is entitled to initiate an action for corporate insolvency resolution against the corporate debtor. The second limb is with regard to insolvency resolution process initiated by an operational creditor. Now, a financial debt, of course, is, as we said, is one which broadly pertains to amounts due under loan arrangements. And whereas operational debts, which are owed to operational creditors, is essentially defined as any amount which is due under any contract or any arrangement for provision of goods and services, and it has also been extended to cover any dues under employment contracts, etc. So any operation, any creditor who falls within this category, as in who is owed amounts owing to certain goods supplied or services rendered, will fall within the category of operational, their debt will fall within the category of operational debt, and therefore they would qualify as operational creditors under the Insolvency Code. Now there's a fundamental distinction between the trigger point for initiation of a financial debt and an operational debt vis-a-vis CIRP. As I said, moment there is a default in the in payment of a financial debt, the financial creditor is entitled to approach the NCLT with a petition for initiation of CIRP. Whereas in the context of operational debts, when there is a default in payment of an operational debt, first and foremost, the operational creditor has to issue what is called a statutory demand notice under Section 8 of the Insolvency and Bankruptcy Code. Now, this notice, broadly speaking, would encapsulate what is the character of the debt, what is, how the debt has come into existence, as in through either a contract for sale or supply under a contract for sale of goods or contract for supply of services, how the amount has become due, and would require the creditor to call upon the corporate debtor to make payment of the amount due within a period of 10 days from the date of receipt of the demand notice. Now, in these circumstances, under the scheme of Section 8, the corporate debtor has two options. One option is to satisfy the debt or the claim and notify the operational creditor about the discharge of or settlement of the debt. And the second option is if he disputes his liability to pay that operational debt, then he can issue what is called a notification of existence of a dispute to the operational creditor. Now, in either circumstances, if after the 10-day period, if the corporate debtor does not respond to the demand notice, or responds to the demand notice disputing the debt on certain grounds, then it is open to the operational creditor to approach the NCLT in order to demonstrate that there is in effect or in de facto no real dispute between the parties with regard to the operational debt. That we had the concept earlier Companies Act of a moonshine defense. That language strictly has not found place in the code or in judgments under the code, but the NCLT in those circumstances will then proceed to test whether there is really a dispute which the corporate debtor has been able to make out or not. So that is a process of adjudication with regard to an operational debt, which we will look at in contradistinction to a financial debt in the next section. So the second limb is, of course, where with regard to operational debt, where after the issuance of a demand notice, the amount claimed is not satisfied, then the operational, within a period of 10 days, then post 10 days, the operational creditor gets a right to approach the National Company Law Tribunal with a petition for seeking initiation of CIRP against the corporate debtor. The third category is, and this is of course, operational creditor petitions are governed within the framework of sections 8 and 9 of the Insolvency Code. The third limb is that of a corporate debtor himself approaching the NCLT, stating that he is unable to honor or satisfy certain operational or debts or financial debts, and there have been events of default which have occurred vis-a-vis these financial operational debts, all those details having been placed before the company law, national company law tribunal by way of a petition, the NCLT will adjudicate upon the same and decide whether it's a fit case where the corporate insolvency resolution process against the applicant corporate debtor is to be initiated or not. Therefore, to summarize, there are broadly three categories, limbs under which the CIRP process under Part 2 vis-a-vis corporate persons can be initiated. One is, as I said, by a financial creditor under Section 7 of the Code. Second is by an operational creditor under on a combined reading of Sections 8 and 9 of the Code. And thirdly, the corporate debtor under Section 10 of the Code. Now, all these three provisions will have to be read in conjunction with what are called the Insolvency and Bankruptcy Adjudicating Authority Rules of 2016, which are, and these are the rules through which the manner and procedure for filing and what are the contents of each of such petitions, all these aspects have been detailed out in the adjudicating authority rules. Now, this is the process of having triggered or having the right to approach the NCLT having accrued, and a petition before the NCLT having been filed either by a financial creditor, operational creditor, or by the corporate debtor itself. Then we come to the stage of actual adjudication of the petition by the adjudicating authority, namely the NCLT. Now here, I would again want to come back to explain a very important distinction between the adjudicating, the test or the scope of adjudication by the NCLT is for a financial debt vis-a-vis an operational debt. As I said, the moment there is a great deal of primacy which has been given under the Insolvency Code, as Bala had also alluded to in his introductory portion. One of the principal reasons also for introducing the code was to, in a sense, really give adequate support to credit by financial institutions, because they ultimately are the backbone of the credit system in the economy. So what was happening was owing to various delays which had crept into the process of liquidation under the Companies Act, as well as huge pendency of rehabilitation cases before the SICA. The purpose of the code was essentially to provide for some kind of a time-bound exercise under which this entire process of insolvency resolution could be undertaken, failing which the company would go into liquidation. And the importance of this timeline has been stressed time and again as necessary for the purposes of maximization of realization of the value of the assets which are held by the company. Obviously, companies as a going concern have a lot of value associated with it, which may slowly deteriorate with the passage of time. Therefore, there is an importance given to timelines and the necessary for a time-bound resolution procedure which has been established under the code. Now, given the primacy that financial creditors enjoy under the Insolvency Code, the Section 7 is dovetailed into that concept, and therefore provides that moment there is the existence of a loan arrangement or an arrangement under which there is a particular financial liability upon a company has been established, and there is an inability to pay either whole or in part of such financial liability on the date on which it falls due, a default is said to occur, and automatically there is a right given to the financial creditor to approach the NCLT. Now, when the NCLT is approached with such a case of a default, it will stop its scrutiny to limiting itself only to seeing the existence of such a default. Now, it will not go further. There could be, for example, there's a particular. Let's take an illustration. A company is owed. One particular entity is owed a particular financial debt from a company. Now, that is under, say, one loan arrangement or one loan agreement. That loan agreement, there is an independent loan agreement or independent understanding between the parties, say in the form of amounts which are due to the corporate debtor from the from the entity from the financial creditor involved vis-a-vis any kind of supply of goods or any other transaction. The fact that there is any amount due under the independent transaction will have no bearing at all on the adjudication of the financial creditors petition. That is, this financial creditors petition on a particular loan arrangement constitutes a standalone arrangement. Moment there is a default under that, automatically the process of insolvency resolution can be triggered by a financial creditor. Now, this has to be seen in contradistinction to an operational debt and a petition by an operational creditor. If you were to read sections 8 and 9 of the code, what the test ultimately to deciding whether it's a fit case for initiation of insolvency resolution for an operational debt is whether or not there exists a dispute. Now here, for the purposes of an operational debt, issues of set off, counterclaim, etc., can be pleaded by a corporate debtor as a defense to an action for an operational debt, whereas no such liberty is granted to a corporate debtor vis-a-vis a financial debt. And this constitutes a fundamental distinction between the adjudicatory process for a financial debt and the adjudicatory process for a corporate debt, for an operational debt. I'm sorry. For an operational debt, it is if there is a dispute that has been raised, it is the onus is on the operational creditor to be able to show that this defense has absolutely no plausible basis. I lay stress on this because what the test that has been laid down by the Supreme Court on this issue is that it is the adjudicating authority while deciding on a petition of an operational creditor is not going to look at the strength or weaknesses or the likelihood of success on the merits of such a defense. It is only going to look at the plausibility of such a defense, and moment the defense is plausible, that itself is adequate for the purposes to bring a corporate debtor outside the realm of insolvency proceedings vis-a-vis an operational debt. Now, just to refer to two important judgments on this aspect. The first important judgment, and possibly the first main judgment that came to be passed by the Supreme Court under the Insolvency Code, is a judgment called Innovative Industries versus ICICI Bank. This is a citation being 2018, 1 SCC 407. This laid down the broad distinction between the scope of adjudication of a financial debt vis-a-vis an operational debt, as we had discussed slightly earlier. The second important judgment, which talks about how to construe, how the adjudicating authority would test the existence of a dispute for the purposes of entertaining an operational creditor's petition, that has been considered in detail by the Supreme Court in the judgment of Mobilox Innovations versus Kirusa Software. This judgment is reported in 2018, 1 SCC 353. So these are the two important judgments which draw the distinction between the adjudicating process between a financial debt and an operational debt. Now, moving forward, if given the tests which we have just elucidated in the previous section, if the NCLT is of the view that the existence of a default in the context of a financial debt or the existence of an undisputed operational debt has been proven by the financial creditor or the operational creditor, as the case may be, then the petition would then proceed to the admission stage and would stand admitted, and what is called the initiation of corporate insolvency resolution process, or in short CIRP, would be declared to have been initiated against the corporate debtor. Now, as a consequence of such an order of admission being passed by the NCLT, there are three immediate consequences that follow. First is with regard to the appointment under the court order of someone called an interim resolution professional, or an IRP, in terms of section 16 of the code, in order to take over the management of the affairs of the corporate debtor, in the sense that moment the order of admission is passed and CIRP is initiated, the existing management of the company is divested of all its powers vis-a-vis management of the company, and all those powers come to be vested in the insolvency in the interim resolution professional. Thereafter, there's such interim resolution professional who is appointed within a particular time frame, which is 14 days, has to come out with what is called a public announcement of declaring such an insolvency CIRP process having been initiated against the corporate debtor, and also inviting claims. This is where the proceeding, from the stage of being a proceeding inter partes between a particular operational creditor or financial creditor and a corporate debtor, becomes a proceeding which broadens to include the rights and interests of all the stakeholders of the corporate debtor, and therefore there is a procedure which is envisaged under the code inviting claims from all the creditors of the company, which the insolvency or the interim resolution professional is required to verify and collate. The third and possibly the most important consequence of the CIRP initiation of CIRP process is the declaration of what is called a moratorium, and this is provided for under section 14 of the Insolvency Code, and the consequence of it very similar to the provisions of to the consequences of section 446 of the Companies Act 1956 is that all actions, legal proceedings against the company are in a sense restrained or injuncted pursuant to the declaration of such a moratorium. So there is a complete suspension of initiation of any fresh legal proceedings or continuation of any pending legal proceedings against the corporate debtor. There is also a provision by way of which the corporate debtor itself is restrained from in any manner encumbering or creating any kind of encumbrance on its existing properties. Again, the main purpose being that in the interest of giving the insolvency resolution process its best chance, there is a protection or a protective layer which is given around the assets of the company, so that the value of the company is maintained or protected during the course of the insolvency resolution process. Now, once the CIRP is initiated, the action in a sense moves away from the NCLT and moves into the hands of the insolvency resolution professional, who is to act in conjunction with the Committee of Creditors to see if some kind of a viable resolution plan can be brought into force, or there is some scope. In broadly speaking, the purpose of the CIRP process is to see if there can be some kind of a revival or rehabilitation of the company as a going concern, and if so, the manner in which that is to be implemented. Of course, failing any such process being possible, the company then moves into liquidation, which is the third stage that we will deal with separately. So once the interim resolution professional has been appointed, his immediate obligations are twofold. One is he is required, as I pointed out, to invite claims from various creditors of the company and collate and verify those claims. Secondly, he is required to assess, take stock of the books of account and other financial records of the company and ascertain what the financial position of the company is, broadly speaking. And thirdly, and the most important obligation of the interim resolution professional is, within a period of 10 days of being appointed as the interim resolution professional, he is required to constitute what is called a Committee of Creditors under section 21 of the code. Now, this Committee of Creditors is in a sense almost like a substitute for the general body of the company. You know, in the context of regular company law, you have the board of directors and you have the general body of members of the company. In a sense, the role which is ascribed to the general body of members now in a sense stands with the Committee of Creditors, whereas the resolution professional is kind of in day-to-day management of the company, reporting to the Committee of Creditors. So the Committee of Creditors has a sacrosanct and primary role in the insolvency resolution, in the conduct of the insolvency resolution process. Now we come to the constitution of the Committee of Creditors. The Committee of Creditors comprises of all financial creditors of the company. Now this is, and to that extent excludes any representation from the operational creditors. Now this again is an instance which again reflects the primacy that has been given under the Insolvency Code to financial debts vis-a-vis operational debts. In the sense, it is the financial creditors who are going to determine the future and the fortunes of the company under insolvency resolution. Now, just on a side point here, and just to highlight one important judgment of the Supreme Court, this distinction that time and again under the code has been drawn, vis-a-vis the treatment of financial creditors and operational creditors, came up as a challenge to the constitutionality of the provisions of the Insolvency and Bankruptcy Code, in the sense that the primary thrust of the challenge was that such distinction between operational and financial creditors is unreasonable and therefore arbitrary and discriminatory, and falls foul of Article 14 of the Constitution. Now that came up for consideration by the Supreme Court in the judgment of Swiss Ribbons versus Union of India, which is reported in 2019 4 SCC page 17. And here, but here the Supreme Court clarified that there are, and more so in the context of the deliberations of the Insolvency Committee, which was constituted prior to the coming into effect of the code, of the importance of the financial creditors to the credit system in the economy, and therefore found sufficient basis to distinguish or to differentiate between financial and operational creditors, and therefore the provisions of the Insolvency and Bankruptcy Code providing for distinctive treatment of the two categories of creditors came to be upheld. Now, moving back from this side point, coming back to the constitution of the Committee of Creditors, the Committee of Creditors is, as I said, to constitute all the financial creditors of the corporate debtor. Now, in a circumstance where there are no financial creditors of the company, the regulations or the rules accompanying the code provide that in those circumstances alone, the operational creditors would constitute the Committee of Creditors, and 18 of the largest operational creditors in terms of size of the debt would essentially constitute the Committee of Creditors, only in circumstances where there is not even a single financial creditor of the company under CIRP. Now, once the Committee of Creditors is constituted, the first act that the Committee of Creditors undertakes is to decide whether they want to proceed with continuing with the existing interim resolution professional, or they would want to replace him by another resolution professional who is to take charge of the CIRP process. So that is the first decision that they have to take, either to continue with the IRP or to appoint a new resolution professional. Now, thereafter comes the manner in which the Committee of Creditors is meant to act. The Committee of Creditors is meant to hold meetings at regular intervals, and in these meetings, of course, there is representation which is provided for the ex-directors, as well as there is provision for one representative of operational creditors as a body, provided the total exposure of the company towards the operational debt in the whole is equal to or more than 10% of its total debt exposure. So if the operational debt constitutes 10% or more of its overall debt, then the operational creditor gets one position of representation in the Committee of Creditors, but this also is divested of any voting share or any voting right. So the voting right to decide upon manner of proceeding, conduct of the insolvency resolution process remains with the financial creditors only. Now, once the Committee of Creditors is constituted, the Committee of Creditors is functioning, the resolution professional appointed by the Committee of Creditors is thereafter required, after collating the claims that are invited and received pursuant to the public announcement, and he is thereafter required to come up with what is called an information memorandum, which is provided for under section 29 of the code. Now, the information memorandum is essentially the broad analogy that I could draw is it's very similar to a notice inviting tender for say acquisition of a particular asset or a company. So what the insolvency resolution professional is required to do is to record the financial position of the company and place it in the public domain by way of an information memorandum, providing all relevant information on the basis of which a possible applicant can apply with what is called a resolution plan in order to see, providing some kind of a framework or a roadmap for revival of the company. So the information memorandum invites applications for resolution of the company under CIRP. Now, of course, along with in section 29 itself, there is power and there's a responsibility which is vested upon the resolution professional to provide all relevant information and access to books to any such resolution applicant who intends to participate in the process of seeking to revive this company through a resolution plan. So once after the information memorandum is in place, within a specific time frame, there is a requirement for any person interested in reviving the company to file or submit what is called a resolution plan with the insolvency resolution professional. Now this resolution plan principally will deal with two aspects, which is quite logical. One is as to how it intends to address the various debts due from the company in terms of addressing its existing financial exposure, both in terms of financial debts as well as operational debts. And the second aspect is, of course, the manner in which it seeks to restructure the management of the company and essentially take over the company. So these are broadly the two aspects that the resolution plan is required to include. Now, here there is an important aspect which requires to be highlighted, is that considering the operational creditors have no representation or at least voting rights on the Committee of Creditors, an important question arises as to how its fundamental interests are to be protected in these circumstances, because normally speaking, it would be commercially logical for a financial creditor to only consider addressing of its debts in any resolution plan and not consider the rights and interests of operational creditors. Now, this is where section 30 of the Insolvency Code, which provides for certain basic requirements that the resolution plan has to meet, provides that one fundamental requirement of while addressing the rights of operational creditors is that any amount which is to be proposed to be paid to operational creditors. Now, one fundamental aspect of a resolution plan practically is that in such a resolution plan, both financial creditors and operational creditors 90% of the time are bound to take a haircut on the amounts due to them. But to ensure that the rights of operational creditors is not compromised below a point, in the requirement that has been introduced under the code is that under no circumstance will the amount payable to operational creditors be lower than the amount that would be realized from them from the liquidation estate in terms of the priority of disbursement under liquidation. Now, to put it simply, if the company does not revive under CIRP, the company goes into liquidation. Now, in the liquidation, there is a particular liquidation estate, which is the assets of the company that come into focus and which would be subject of sale in order to disburse the amounts realized from the sale amongst the various categories of stakeholders in terms of a particular priority, which was earlier the regime under the Companies Act also. Now, while doing so, when deciding upon a resolution plan, the resolution applicant and the COC has to be concerned or has to apply its mind to the fact that the amount that is realized by the operation creditor should not be less than what it could realize from the liquidation estate. So that is a fundamental kind of a protection or a base protection which is provided to operational creditors. Now, after the resolution plans are submitted, these resolution plans are meant to be placed provided they meet the various eligibility criteria provided under section 30. As I said, it has to provide for a plan for implementation, has to provide for manner of addressing financial and operational debts, and a manner for taking over of management. If these various tests are satisfied, then the resolution professional is required to place these various resolution plans before the Committee of Creditors. And the Committee of Creditors is required to apply its mind and test the feasibility and viability of each of these resolution plans to see if any resolution plan meets its satisfaction with regard to a reasonable plan under which the company can be revived. Now it's important to note that there was, of course, a great deal of deliberation and debate over what is provided what are the kind of tests that such resolution plans have to be put through by the Committee of Creditors. And broadly speaking, the courts have taken the view that the manner of testing of the resolution plan is something which is totally or completely within the commercial wisdom of the Committee of Creditors, and it is something that the courts would not interfere or intervene in. So therefore, there is a great deal of discretion which is given to Committee of Creditors in deciding upon the viability and feasibility of a resolution plan. Now, if a resolution plan passes muster with the Committee of Creditors by meeting the approval of 66.66% of which is in effect 2/3 or majority of the voting share of the company of the Committee of Creditors, then it is said to have been sanctioned by the Committee of Creditors, and thereafter it moves into the realm of approval by the NCLT as the adjudicating authority. As in just like we have the procedure for sanction of any schemes of merger or amalgamation or rearrangement in the context of the Companies Act, in the context of mergers and amalgamations, you have a similar sanctioning power which is vested in the NCLT vis-a-vis sanctioning of the resolution plan. And again, while doing so, it has been reiterated by the Supreme Court that the court will only concern itself with looking at whether the fundamental legal requirements of a resolution plan have been met, and beyond that, it will not go into the realm of commercial wisdom of the Committee of Creditors in either accepting or rejecting a resolution plan. Now thereafter, once the resolution plan on those parameters may either be sanctioned by the NCLT or rejected by the NCLT, and that of course order is subject to appeal before the NCLAT and in course before the Supreme Court as well. So that is where the adjudicatory process of the NCLT comes back into focus. Till now, from the time of admission of the CIRP till the stage of sanctioning of the resolution plan, the NCLT took a back seat and left the entire CIRP process under the court to be driven by the COC. So here is where the matters come back into the realm of the NCLT to decide whether the resolution plan is to be implemented or sanctioned or not. If it is sanctioned, then the resolution plan is thereafter implemented and is deemed to be binding. Most importantly, such resolution plan, like in the context of schemes under the erstwhile Companies Act as well as Companies Act 2013, are meant to bind all creditors and stakeholders of the company. Therefore, or irrespective of whether each individual creditor may or may not agree to the terms of the resolution plan, it is binding on one and all. So this covers the process of CIRP. And one important aspect which I'd like to lay stress on, and which again, it's a thread which I said flows through the entire code, is the importance given to a time-bound procedure. Now that time-bound procedure for CIRP is encapsulated in section 12 of the code, wherein, and now by the latest amendment of 2019, there is an outer time limit of 330 days, which is provided for completion of the CIRP process. Now, just to break it down, under normal circumstances, the CIRP process is required to be completed within 180 days. Now, given in circumstances where the CIRP process for a variety of reasons cannot be completed within 180 days, the Committee of Creditors is entitled again by a voting percentage of at least 66.66% to approve an application being moved before the NCLT for extension of the CIRP period. Now, if such resolution is passed by the Committee of Creditors, then a resolution professional files an application before the NCLT, and the NCLT is entitled thereafter to extend the CIRP process by a further 90 days. And this 90-day period is the maximum period for which the CIRP process can be extended by orders of the NCLT. Now, then a question, of course, which automatically arises is where there are legal proceedings. For example, assuming during the CIRP stage, the claims as verified by the resolution professional, there are certain issues which arise vis-a-vis certain claims verified by the resolution professional. Now, broadly speaking, those have been made subject matter of challenge before the NCLT by a host of creditors by resorting to the provisions of Section 60, Clause 5 of the NCLT of the code. Now, these sort of legal proceedings could, in circumstances, delay the process of the CIRP. Now, therefore, beyond the 270 days, that is 180 plus 90, there is a further buffer of 60 days, which is provided for under the code, which we have to accommodate for any legal proceedings that may delay the CIRP process. But the wording of the code has been such that to say that beyond the 330-day period, notwithstanding legal proceedings, etc., there's no scope for the CIRP process to be extended. Now, this raised an important question as to the sanctity of this 330-day period and inclusive of legal proceedings, to suggest that in lot of circumstances, considering the workload that the NCLT holds, the explosion of dockets, etc., what if the litigants are not the persons to whom any delay in the process is attributable, to what extent should they suffer on account of delays which are inherent in the system itself, in the judicial system itself? And in that context, the Supreme Court has taken note of the long-standing legal maxim which provides that actions of court can prejudice no one. Relying upon those settled principles, the Supreme Court has taken a view that the mandatory nature of the 330-day period would render the set provision of Section 12 arbitrary. Therefore, it has read down that provision to say that, ordinarily speaking, the process has to be completed within 330 days. And in certain exceptional circumstances where the NCLT for reasons is not able to complete the process and feels a need that the process be extended in the interests of the corporate debtor, this IRP process and the stakeholders, can extend it beyond the 330-day period also. Now, that clarification came by way of an important judgment of the Supreme Court in the case of Committee of Creditors of SR Steel versus Satish Kumar Gupta, which is a judgment which is reported in 2019 SCC Online SC 1478. So here, this aspect has been importantly clarified by the Supreme Court, and this limited carve-out has been clarified by the Supreme Court, and the provision has been read down accordingly. So now we have dealt with the adjudication process, admission process, CIRP process. Now, assuming the CIRP process fails, automatically the next stage which the corporate debtor has to move into is the stage of liquidation. And this is provided for under the chapter specific chapter on liquidation under the code, which starts from Section 33 onwards. Now, broadly speaking, when the company moves into when the CIRP process fails or does not meet the requirement of a resolution plan sanctioned by the NCLT within the time period, the NCLT is required to pass an order placing the company in liquidation. And while doing so, it can decide either for the resolution professional to continue as the liquidator of the company, or can decide to substitute that resolution professional with someone or some other qualified resolution professional to act as a liquidator of the company. Now, liquidation, this phase of liquidation, in a sense, is broadly similar to the framework for liquidation, which was provided for, which is under the Companies Act also. Such liquidator is meant to do two important tasks. One is, it is meant to do a final adjudication of all claims of creditors of the company in order to ascertain what is the total debt exposure of the company. And second and most importantly, of course, to provide for a mechanism for sale of the assets of the company in order to realize maximum value, and thereafter, of course, disburse the assets of the company to the various stakeholders. Now, this process of the manner in which now one important question which of course arises in the context of the liquidation process is, in the CIRP process, you would have noted that the only relevant factor to determine the eligibility as a financial creditor is whether you owe a financial debt or not. And such a financial creditor could be an unsecured financial creditor or could be a secured financial creditor. But in the context of liquidation, there is an important distinction which is again brought in vis-a-vis a unsecured financial creditor and a secured financial creditor. A secured financial creditor under section 52 of the code is given an option. Earlier, under the earlier Companies Act jurisdiction, we had the process of a secured creditor deciding to either stand outside or within the liquidation process or the winding up process under the Companies Act. That similarly has been mirrored under the code under section 52, where an option has been given to the secured financial creditor to decide whether it wants to realize its debts by resorting to enforcement of the security granted by the corporate debtor, or it wants to merge its secured asset with the liquidation estate and partake the distribution of assets from the liquidation estate under a particular priority which is provided for under section 53 that we will come to. So that is an option which has been given to the secured financial creditor. Now, assuming the secured financial creditor resorts to enforcement of its security and realizes and therefore gets a primacy and realizes whatever dues in priority from the secured asset, thereafter, it is important to note that its priority in terms of disbursement from the general liquidation estate falls to a position below unsecured creditors. Whereas, if it chooses to merge its liquidation estate with that of the overall liquidation estate of the company, then it attains a primacy which is only in terms of priority of repayment, which is only below the insolvency resolution costs, and it is on par with the priority which is given to workmen. Therefore, this takes us to the priority under of repayment or disbursement of dues under the liquidation proceedings under section 53. As I said, the primacy, the first and foremost dues which are to be cleared under amounts realized from the liquidation estate are towards insolvency resolution and liquidation costs, which are borne by the RP or by the liquidator as the case may be. After satisfaction of those, then you come to the next category of priority, which is workmen and secured creditors, which again rank pari passu. Thereafter you proceed to the third category, which is unsecured creditors, and thereafter to, as I said, secured creditors who choose to enforce their security interest. So this is broadly the manner in which the priority of repayment or of payment is made out under the code. And of course, as I said earlier, that orders of, and then we move to the section on appellate authorities. The appellate authority, of course, to the adjudicating authority, the NCLT, under the part 2 of the code is the NCLAT, which gets its appellate jurisdiction against any order of the NCLT under section 61 of the code. And of course, an order from the NCLAT can be challenged before the Supreme Court under section 62. So this, and ultimately, once the disbursement of all assets and the liquidation process is completed by distributing all the by selling and distributing the proceeds to the various stakeholders. Then there is again the NCLT's approach to pass a formal order of dissolution of the company under Section 54, which ultimately brings the entire process to an end, and the company thereafter ceases to exist in the eyes of law. The corporate debtor ceases to exist in the eyes of law. So this, in broadly speaking, is the framework of the insolvency resolution process and liquidation vis-a-vis companies under the Insolvency and Bankruptcy Code. There are just two important points I'll just end with, which are specific to the context that we are presently in, which is the COVID pandemic, and of course the heavy implication that it has had on the existing stressed assets being further stressed, and therefore the large amount of companies which are now likely to slip into insolvency owing to the existing lockdown scenario. There are two specific reliefs, in a sense, which have been granted by the government in the context of the COVID pandemic. One relief is in terms of a notification under Section 4 of the Insolvency Code, where earlier the threshold for approaching the NCLT for any action for triggering CIRP was a debt of a minimum of 1 lakh of rupees. That amount has been revised to 1 crore in order to reduce the number of companies or to reduce the stress on the NCLT, as well as provide some kind of a reprieve to small and medium enterprises which are undergoing a difficult time presently in terms of repayment of debt. Therefore, henceforth, you can only approach the NCLT for triggering CIRP for a debt which is equal to or more than 1 crore. That is in terms of a notification under Section 4. The second relaxation which has been provided during the lockdown period is, as I clarified, is that the entire CIRP process and liquidation process is meant to be undertaken under a specific timeline. Now, obviously, those timelines are incapable of being met in the context of the existing COVID pandemic and lockdown. So there has been a specific regulation, namely Regulation 40C, that has been incorporated under the Corporate Insolvency Resolution of Corporate Persons Regulations of 2016, under which during the period that has been lost during the lockdown has been excluded for the purposes of the timelines prescribed under the code. The third and final modification, that is relaxation, that is sought to be brought is a major relaxation, which of course the decision appears to have been reported but not formally notified or legislated upon yet, which is that there's a proposal to keep sections 7, 8 and 9, which are the triggering provisions under the code. They are meant to be kept under abeyance for a period of anywhere between 6 months to 12 months. Now, this of course being in the nature of a suspension of a legislative enactment, I think it has been proposed that this be introduced by way of an ordinance. But to my knowledge, that ordinance has not yet been brought into force. But this is, of course, something which the government appears to have in principle decided upon and will possibly be implementing very shortly. So this covers the broad overview of the Insolvency Code for the purpose of my presentation. I'm sorry I've exceeded my time, but I'll be happy to address any questions that you may have.
Thank you so much, Mr. Arun, and that was definitely a great show. We do have some questions, I guess, and first is Madhuri ma'am. I'll mute her so that you can answer her.
Please.
Just a second.
Arun, thank you very much for that comprehensive presentation. It's such a elaborate code, and we found that you have actually concise in a very precise manner.
Thank you so much, ma'am. Thank you.
I have two questions here.
Yes, ma'am.
One is the one which this extension that has happened during the COVID period from 1 lakh to 1 crore.
Yeah.
Is it for a limited timeline only, like for the 6 months that they have mentioned, or is it for or is it going to be there permanently or something like that?
Ma'am, the notification that they have come out with doesn't indicate any time frame for this change. It is a revision that has been introduced, which as of now will apply, to my knowledge, to any proceeding that is freshly initiated. But there is no timeline for this, in the sense that now if there is to be a further revision, either downwards or because there cannot be any further revision upwards under the Act, because the cap of 1 crore is the maximum to which they can cap it under the provision itself. That is, they can't make the trigger point higher than 1 crore. And so they have chosen to keep it at 1 crore. Whether they decide to reduce it hereafter will again have to determine. I guess they want to take a call on that depending on how these circumstances pan out in the future. But as of now, any fresh resolution, any fresh trigger will have to be for claims upwards of 1 crore. Upwards of 1 crore.
Yeah, thanks. The other question is regarding the moratorium period.
Yeah.
Now, during the moratorium period, there cannot be any action against the debtor. The no prosecution can be initiated or anything of that sort. No proceedings or no orders can be passed against it.
Yes, ma'am.
Now, is there a bar or somewhere where after this moratorium period is over?
Yeah.
I don't see per se. I mean, that is there a difficulty in actually passing an order after that? But do you think there's any embargo on that actually?
No, ma'am.
Even though the process is going on. Sorry, the process is still going on, but the moratorium period is over. So obviously the COC is meeting up and they're still going on with the resolution process and other things.
Yeah.
During that time.
Yeah. Yeah. So during that period again, the moratorium definitely is once the CIRP process is over, the moratorium is lifted. Therefore, that embargo ceases to exist. So thereafter, it is more in the sense of there is of course a timeline which is prescribed within which the liquidator is to liquidate the assets, but it does not. The process that is thereafter envisaged is for any such creditor to thereafter maintain its claim before the liquidator, and the liquidator is given a positive power to adjudicate on any such claims. So this provision has, if read with two other provisions under the code, which provide for exclusion of the jurisdiction of civil courts, as well as section 238 of the code, which gives primacy to the provisions of the insolvency code over other provisions of the any other enactment. My reading would be that thereafter, even after the moratorium is lifted, the normal procedure would be for any such creditor to thereafter maintain his claim with the liquidator, and the liquidator is given a positive adjudicatory power under section 40 of the code to adjudicate upon these claims, and these claims as adjudicated by the liquidator can also thereafter be appealed against before the NCLT by resorting to provisions under section 41. Therefore, that in my view would be the framework which would govern any claims against the corporate debtor in the liquidation scheme.
Sorry, in continuation of whatever you said, don't you think then the liquidator has been given an overreaching power in terms of actually admitting the claims of the credit of the debtor? I mean, from where I'm coming, see, being in the tax side,
yes.
So would a liquidator know whether this taxation, the tax impact, or the tax liability of a debtor as to see whether he is or he's not liable, which is not within his purview or jurisdiction to adjudicate those kind of claims, including the NCLT, I mean.
I understand, ma'am, but I think that is at some level, I completely agree with what you're saying, and that problem gets accentuated even more in the context of the CIRP process, because like I said, in the CIRP, at least in the liquidation process, you have a process of adjudication by the liquidator and an appeal before the NCLT. In the CIRP process, the resolution professional merely verifies and collates the claims, and there is no specific provision given for any creditor to challenge the manner in which the claims are verified by the resolution professional. And this is particularly problematic because assuming that the claims are crystallized in the CIRP process as X amount, and the resolution plan is thereafter formulated and approved based on that amount, the creditor loses all his rights to challenge or any manner on his claims thereafter. Compared to that, liquidation process is slightly more robust, as you said, in the sense that at least an appellate provision is provided. But on your specific point, yes, it is a overarching power which is granted to the NCLT. But I think the reason or the rationale for that is they want some kind of certainty or finality to be associated with the process of liquidation under the code. Because moment you say that the NCLT will not be the final adjudicating authority on this, you will never have a scenario where the liquidation process can can reach its logical conclusion, which is again the problem that we faced under the earlier enactments. So it's basically a kind of a toss-up between those two aspects which have been sought to be addressed in this manner, obviously to a large extent at the hardship of creditors and government or statutory bodies, but that for the present is the manner in which they have chosen in their wisdom to formulate or structure the code.
Yeah, fair enough. Thank you. Thank you very much.
No problem, no problem.
Sir, your question in chat, could you please repeat the sections that have been suspended for some time as a part of COVID relief, the last part of your presentation?
Yeah, see, that has, I have only followed from certain reports in the media, because as on date, I'll try to clarify, to my knowledge, as on date, there is no ordinance or notification that has been brought into force. But what has been reported in the media is the government's decision that the provisions for triggering of the insolvency code, that is namely sections 7, 8 and 9, are intended to be kept under suspension for a period of 6 months to 1 year. Of course, the exact what are the various provisions which will as a consequence be placed under suspension will be matters which will have to be worked out in terms of the actual wording of the ordinance or the legislation as and when it comes in. But this is what I have been able to gather from newspaper reports.
Okay. Sir, I do have a question. I see a structured or an organized mechanism being put into place. Whether it was fruitful that it can the objectives were fulfilled out of this act.
No, I mean, I see. Obviously, any enactment when it comes into place, there are bound to be teething problems from time to time. Like, for example, if you see for a code which was enacted as recently as 2016, you've had amendments in 2017, 18, as well as 19. So there is a sort of a review that is constantly happening, and there is a process of streamlining, which is always work in progress. So obviously, initially, to a large extent, the time-bound nature of the process was suffering because of the general problems which plague our system, which is adjournments and various applications being filed and a proliferation of litigation. But now increasingly with the wordings of the code, and as I said, the importance of the 330-day timeline under the CIRP section, etc., an attempt is being sought to be made to streamline the process. And slowly I do find that the NCLT and adjudicating bodies are becoming more and more sensitive to these aspects and are working accordingly. But it's always a toss-up between how important is how critical is the timeline vis-a-vis ensuring that every stakeholder is given a right to agitate his concern or his grievance. That is always a constant tussle between the two. And as of now, the code is very highly, in my view, very highly bent or weighed in favor of the timeline vis-a-vis actual redressal of the grievances. But that is again based on a larger objective, which is a legislative objective that we may not necessarily be best placed to comment on in terms of legislative policy.
Okay. Thank you so much, sir. Thank you. That was a wonderful presentation. Nitty-gritties of the codes have been put out in a very easy manner.
Sorry, I just opened the Zoom chat. I'm hoping I haven't missed any other questions because I wasn't focusing on it. Is there any other questions that?
There is one question now.
Yeah.
Whether liquidator having power to deal with workman rights to set aside his dismissal order. It's from Mr. Rajaram.
At the stage of liquidation, the liquidator has been given with no such. It has been given with certain very specific powers, which is the powers to actually adjudicate because by the time a company moves into liquidation, it is not meant to be a going concern. Therefore, all the powers which vested in the erstwhile management in any case vest with the liquidator. So during the liquidation process, at least under the framework, it is not envisaged that these kind of disputes with regard to dismissal of employees or etc. would arise, because it's the liquidator who's in charge, and the liquidator's role as under the liquidation process is very specific and as detailed under the code itself, which is to ascertain the asset base, ascertain the creditor's base, and sell the assets to meet the creditor base to the extent possible. Therefore, the likelihood of such this thing may not arise, but of course, under a general power exercised as in management, there's a possibility that liquidator may take such a step, in which case an appeal against any such order of the liquidator can be agitated before the NCA. Yeah. Hello.
Is there any other questions, or shall we wind up, participants? Okay. I see there are no questions, sir. Thank you so much. We'll wind up now. And
thank you so much for the opportunity. I'm sorry to keep you people held back for longer on a Saturday.
No, sir. We should be the one thanking you. Okay. To the participants, we are having another program on Monday where it will be the speaker will be Mr. Gupta Ravi, talking on fraudulent representations in contracts. Please do connect up with us and get enriched by the program. Thank you so much for attending. Thank you.
Thank you, everybody. Bye.
Thank you, sir.